We're going to get started in just about 30 seconds. We're going to have a little bit of a updated agenda. Instead of Public Defender's Council going first, we're going to do Superior Courts. But about 30 seconds, we'll get started. All right, I'm going to go ahead and call the meeting to order. Thank you for being here today. I know many of you are looking forward to having a little bit longer of a weekend. But this is important stuff that we wanted to hear this week so we could discuss it next week and have a little time so we can make good decisions for these groups. Again, we're going to go out of order just a little bit. We had Public Defender's Council going first. We're going to have them be on deck. We're going to do Superior Courts first. So if Judge Hightower, if you'd like to come up.
All right. Thank you, Mr. Chairman. You kind of lead. I can walk through. I do have the sheets here, and I can go through the tracking in my list, or I can take your questions in the order that you wish. How would you prefer?
You go ahead and go through, and if someone has a question, we'll just interrupt you if that's okay.
All right. Yes, sir. All right. Well, then starting at 9.1, this request that we have is for a new HR position. Currently, since 2016, we've had the same person doing this role. One person does our payroll and our human resources functions. Right now, that one person is doing that for 699 employees, roughly 100 senior judges, 230 Superior Court judges with their law clerks, and 230 assistants, roughly. In comparable agencies, that same position, usually comparable agencies have anywhere from 3 to 5 people doing that role. So this would be allowing us to add an additional position to assist our one person who conducts both those requirements. Moving on to 9.1.2. This is for our office staff for the council. These are for 8 targeted positions there. In our research and looking back, I believe that our council staff has not requested any type of increase in just over a decade. And so as of right now, just for an example, I think there's roughly 32 to 33 different agencies comparable throughout the state. And I think our executive director is right now, if one's the top, I want to say he's probably somewhere around 32 out of the 34 down that list. And again, they've not had a seat or sought out an increase in a little over a decade. And so this is just to help them and assist them there. As far as, I think it's 9.2.1, this is placed in for our district court or judicial administrative districts. Right now, to give a little bit of context here for this request, these 10 positions for our JEDs were created in 1977. When that was created, there were roughly 42 circuits with 86 judges. We still have the same 10 JEDs, and now we have roughly 230 judges and 51 circuits. And so the number of people have not increased, but the number of people that they facilitate and assist has almost tripled, and the circuits that they accommodate has increased by roughly 12. And so they are looking for an increase there to help assist with the capacity that they're having to deal with. And so that's where that request is coming from. Moving on to the next, if you go to 9.3.1, this is getting into the employer contribution rate for JRS. And that's just something that's each budget every year. If you have any questions, I'll be happy to take them there. Next is 9.3.2. This amount here is for the new compensation structure that the legislature passed last year. This is the annualizer to fully fund that. Last year, y'all funded that for a partial year. This is the annualizer to actually make that full moving forward. I would draw your attention to this. In the amended budget, I believe y'all took some portions there that were for, that would have been to judges who did not opt in, right? So in this, our request is that you don't do the same here, but hold and wait till the amended budget. And the reason we're asking that is if you were to take it here, the same as you did in the amended, these judges can opt in at any time. In the amended budget, when you took those funds for judges who had not opted in yet, right, we're really just looking at a 4-month window. So we're not going to get in any danger, really, and we think it was appropriate for you to take those funds back. You didn't hear anything out of us, because it's unlikely that anyone's going to opt in that hasn't already opted in the next 4 months. And if a judge were to retire, and then his or her predecessor, they'd automatically be in, right? It'd be unlikely that position would get filled within the 4 months that we have coming up. Do you follow there? And so, but with this, if you were to take it in this portion, these judges can opt in, or someone could retire, and we could get ourselves into a bind rather quickly. But if you held off and did the same thing in the amended that you did this year, we would have a very good number to give you, the same as we did this year in the amended, and we'd be in a much safer place. So that would be our request there, and that's why. Next,
I do have a question real fast. So on,
yes,
on 932, not only is that implementing, that's implementing the full 100% of what you could get.
Yes, sir.
Okay.
Yes, sir. Yes, sir.
Okay.
That, and again, that's the annualizer. Y'all have already done that for the partial year. This is just annualizing moving forward. Yes, sir. Next is 9.3.3. And I'll just do these three together: 9.3.3, 9.3.4, and 9.3.5. These are for the judicial circuits that were created in the 2025 session, and this is just to fully fund those. Now, you'll see these repeated again on the next three: 9.3.6, 9.3.7, and 9.3.8. The reason those are in two different spots for the same three circuits is because the top three, that number there, that was the portion for the old salary amount. Well, the three that were created, they automatically are in the new payment structure, and so we were required to request the three below that to get them to the new payment structure that was also implemented in the same year. And so that's why you have three different circuits in two different spots requesting two different bundles of money. One is for the old payment structure. One is to get them up to the new payment structure, since they're required to be in that new structure. All right. Next is 9.3.9. This request here goes towards respecting the model that the legislator created. And I want to say, I think looking at this, I think the legislator was very wise in how they structured this and how they did this model. I know that legislation gets passed in 1 year. However, this is a work and a body of work that had been 10 years or more trying to get to this point. And so this is a reflection of us trying to honor and respect the model that is there. If you have any questions, I'm happy to take those.
I don't see any questions.
All right, thank you. 9.3.10. This is to get us for our senior judge days. This is to put us at 10.5 for our senior judge days. I know that prior meetings that we've had, I believe in December, there was a representative that said, well, what would it be for 15? So I did want to give you that number. 15 was what we had prior to COVID. If you wanted to put us at 15, it would roughly take $871,000 additional dollars to put us at 15. And again, one of the state reps had that question, so I wanted to give you that. Next, 9.311, 9.3.12, and 9.3.13. These are for new judgeships that have currently passed the House, but have still yet to pass the Senate, I believe. And so this is a request in anticipation of those three judgeships passing. If you look here, it says effective July 1, and that's where that little over $500,000 comes from. I believe the House changed that to January 1, and so your sheets may show half of that amount, and that's why you would show a different number for half the amount, because the House changed the effective date from July 1 to January 1. The last two, 9.3.14, 9.3.15, these are just givebacks. These were funds that were given to new judgeships for office equipment for them to set up their office and get things going, and this is just an annual thing that we give back once those offices have been established and set up. I'm glad to answer any questions that anyone might have.
I appreciate the presentation. Are there any questions from the members of the committee? All right. Representative Holcomb.
Thank you, Mr. Chairman. Judge Hightower, thank you for your presentation.
Yes, sir.
I have one question, which is on the 9.3.10 for the senior judge usage. My understanding is that the senior judges help to alleviate like backlogs and pressure and individuals being out.
Yes,
so
sir.
Can you just give us a little bit of context of if we were to go with the 871,000 with the 15, how that would benefit the flow of cases?
Yes, sir. I will answer for myself. So the way that I try to utilize my senior judges are for trial weeks. My backlog happens when I have trial weeks and I can only try so many cases at one time, right? There's only one of me, and so I can only try one case usually in a trial week, sometimes two if one goes rather quickly. Whereas senior judges for me come into effect is not so I can go and do something else or be off or be away from the job. Senior judges help me because I can run a second courtroom. And when I have defendants and the state and they kind of know I can only do one thing at one time, that's where everything flows very smoothly, and it bottlenecks at my trial week, okay? And so when I have the senior judge days for me, it allows me to open that bottleneck up and get more cases passing through at a faster rate because I have another judge in a courtroom right beside me, and it's twice the workflow. And so that's how I utilize those. Now, I will say, in doing that, these senior judgeships, when you do it that way, they can go quickly because a trial week is 5 days. Now, not every trial goes 5 days. I let y'all know that I was in trial this week, and y'all are very kind to accommodate. I approached earlier and let y'all know that came to a verdict last night, but we don't know that. But this week, if I'd have had another senior judge there, I'd have probably had 3 days used up just this week. But that's how I would utilize these days. Yes, sir.
Any other questions from the committee? Okay, I do have just a question myself. So on the increase in pay that started in January, and the opt-ins, most people opted in.
Yes, sir. I think we only had 33 judges that did not opt in. Yes, sir. So roughly 200 opted in, 33 did not.
Is there contentment amongst the judges? Hey, we got this done. This is started. This feels good with where we're going and the direction that we're going amongst the.
I think
this is a few years that kind of came to fruition, really starting January for as far as the pay.
I think there's a large feeling of gratitude that the state was able to work with us and get us where we need it to be. And I know our counties appreciate it. I know that we appreciate it. So I think across the board, if you look at the majority of our judges, almost 200 out of our 230 judges opted in would show much gratitude. And even for the way that y'all structured this. If you again go to 9.3.9, the way that y'all structured this, I think, was very wise. Y'all allowed us a way to request an amount moving forward so that we don't run into the same problems of the past of having to fix something that was left unattended for 10, 12, 15 years. And it's left again to y'all's wisdom of how you see fit to use that model moving forward. But I think y'all gave us a wonderful model of how to come to y'all in an appropriate and respectful way to have those funds there and for y'all to use y'all's wisdom of how to use that moving forward. So y'all did a great job, and we're very thankful for it and grateful for it.
Yeah, I appreciate that. I don't think I was looking for I appreciate y'all thinking it's work. You know, the argument was made, hey, people who are the best of the best aren't willing to stay in the profession or looking to get out, or they're not willing to do it because of the pay. Making sure that we're addressing that so we continue to get, you know, a good solid compensation package for judges, you know.
And to that, Mr. Chairman, I think we're grateful, and I think that this is working. And again, it goes to the model that we're here. Y'all essentially put this model together that allows us hope each year that we'll continue to move forward in the light that the model was made. In the spirit of the law that this model was made was that we would come and make the request that we've had here and that the model would work to some degree. And so I think we're on the right path. This model gives us an avenue of hope to do that each year.
Great. Any other questions? Really appreciate your presentation. Thank you for being here. Thank
y'all.
Mm-hmm.
Thank you for taking me out of order.
I did notice you're more than welcome if you're standing in the back. Take up the back 3 rows. We don't have a huge committee here, so I'm sorry I didn't notice that a second ago. But we've had a lot of people pass out from standing, you know, locking their legs and stuff. I don't want that to be the case here. So please utilize Representative Barrett. You're welcome to move up further. I'm sorry about that. Okay, Public Defender Council. Director Ali. Come on, sit down. Okay. You're making me nervous standing up back there. Go ahead and have a seat now. All right.
Good afternoon.
Good afternoon.
Good afternoon. On behalf of the Public Defender Council, my name is Omotayo Ali, and Chairman Goulet, and to the other members of this committee, I see Judge Gunther, thank you, Representative Holcomb, Representative Park, Representative Barlett in the corner, and Representative Evans right there. Thank you all. And I just want to thank you for all your efforts over the summer for the Common Pay Plan. I cannot thank you all enough. And of course, Ms. Smith right here. How can we even thank you enough for making all of this work? Thank you. We're very grateful to be back here again for 26-27 budget, which is really, really important. I have some people here with me today. Please indulge me to just introduce them because they will be advancing the 2 requests that we have. We only have 2, but those 2 are so important to the operations of GPDC and the operations of criminal justice for the whole entire state of Georgia. May I introduce all of them? Clay Tapley, and these are, I bring 2 CPDs from the trenches so they can speak to you as to what we actually see in the trenches, as to what we actually need, and I hope you you can relate the needs to the request. Clay Tapley is here from Dublin. Letitia Delan is here from a neighboring circuit here in Stone Mountain, and we have our CFO here, Terry Rayford, to go through the tracking sheet. Thank you. And DeAndre Berry will be answering questions on the always famous conflict issues. And if you have legal questions and legislation, I will be tackling that. So we bring the whole force here so that we can answer all your questions. Today, the ask is very few. It's only those two areas. The common pay plan, which all of you were very graceful and gracious to work with us during the summer, and to make sure that we have that parity, we can do retention and make sure that we can keep the operations of criminal justice going and the conflict operations. For the first one, I call Clay Tapley. He's going to talk about the common pay plan and the request that the agency is going to be making. Thank you, Mr. Tapley, for driving all the way from Dublin.
Afternoon, Chairman.
Good afternoon. Thanks for coming back. You came not too long ago, am I right?
You're gonna think I'm not actually working for a living. They've tasked me to address 37.2.6, which is the 7.8 million ask on the pay parity. I just testified before you a week ago, I believe it was, and I sort of made a joke about the parity and sort of said, "Are you for parity?" And you let me off the hook, and I moved on to something else. I was going to address it just in two places because there has been some questions. Actually, I had questions as well. Wouldn't be the first time I got up and spoke and didn't know what I was talking about. But I am the CPD of Dublin, Georgia. If y'all don't know where that's at, that's where you drive through on your way from Macon to Savannah. Like I said, I've been a private attorney, been death penalty attorney, federal attorney. I've been around, and I love the criminal justice system, and so here I am. I was surprised at two different things, the parity issue and the number issue. The parity, I think, is the easiest issue. It's the easiest pull. We have ADAs and APDs all over the state that right now are doing a probation revocation. They're doing something that honestly even the guy being revoked doesn't care that much about. But every day it's a chess match. You got the whites versus the blacks. It is a chessboard where it's went on for years and will go on in Blairsville, wherever it may go on, all over the state. But those are the ones I want to talk about today as far as the parity. I was a little shocked at the number, the $7.8 million number. I think everyone was a little bit of sticker shock because you worked all summer on this. There was a thought that there was probably a difference. I don't think anyone in this room, considering who's in this room, would be surprised that public defenders actually got paid less than the DAs or the ADAs or APDs. But parity is a good thing. Parity is, if nothing else, a nod to all, and I call them kids because I'm getting old at this point, but all the kids in the trenches, because I'm not in the trench, I'm up here in front of y'all. The ones that are actually doing the hard work, they deserve equal pay. They deserve, if you've been 5 years with the DA's office, if you've been 5 years with the public defender's office, they deserve the same pay. And they deserve, just like when I was a prosecutor, to be able to look at the steps and the levels and say, yeah, if I stay here 10 years, this is what I'll make. This is what my retirement. Quite frankly, that is the only reason to work for the state of Georgia, is the retirement and the benefits, or if you love it. So I would encourage y'all to do the parity. For if no other reason, it's a good thing. Back in the day when Herbst first started, I'm sure he was a pain in the butt to deal with. I was a solicitor who believed on the war on drugs. That's how old I am. In 1990s, I was the one who's going out kicking in doors believing we were winning the war on drugs. The thing is, I would have gave you an offer back then, or I would have not accepted an offer that was unreasonable. If we can retain these kids coming and working their way through our system for both of our agencies, they will become reasonable, they understand how it works, and it will move cases faster in the Superior Court, which is what the judges would want to have happen, and it will not happen if we have turnover after turnover after turnover, if you're jumping from one place to another. And honestly, that's about all I have to say about the actual issue of parity, because y'all have done the work over the summer. That's in place. I don't think there's much questions, but I will take questions on that. As to the number, the 7.8 million is where my mouth hit a little bit, like where did that come from? But I've done the research even since we last spoke. You know, we as a agency were brand new babies. I know that's been 20 years, but we were brand new babies, and we did not get put on the pay scale. Partially because, honestly, it was a less than worthy attitude through the whole agency. Maybe we'll just be quiet, and maybe they won't come take it away from us. Because if you remember back in 2006, there was a whole lot of push during that time. We did get on a pay scale up to about 2016, but it was never exactly followed the way it possibly should have been. In 2016, we fell off. Now, that's 10 years ago, and you would say, what has happened for 10 years? What has happened in our agency is, like my chief, who has 17 years experience, she just kept on working. We did get a couple $1,000s here and there from the governor, that kind of thing, cost of living raises. But she never has advanced like she should have, and that's where that number comes from. It is a shocking number, but it also should be a shocking number on the other side. It should be a shocking number that you've got these two agencies working, and one side has $7.8 million to get back to even, to get back to the base. That's not talking about county supplements, county money, in some places where the money may be $1 million more than the public defender's office gets in the exact same county. We just need to get us a base that starts out at even, and then we can move forward. And like I said, it should shock everyone that it is that high. These are people with Social Security numbers. These are current state employees. It's not made up. It's not moved around from different agencies or a made-up position where we're hiding, $1 million worth of people back here. These are real people that deserve this money because they worked that long. And we would ask, or I would ask personally, that be given a priority over everything else. The people in the field that do the work should eat before the leaders do. And that's all I've got to say. And lots of questions, of course.
Yeah, I'll start, and if there's many, go ahead and buzz in if you have questions from the committee. I appreciate you being here. I believe that, I'm going to be frank, I believe the parity didn't happen because public defenders didn't try to make it happen.
Yeah.
And that, legislatively, I've only been in this position, this is my second year, so the history behind it, but I don't think that there was ever really an ask to make parity happen. It did take us a lot of conversation this summer through the director and through PAC to kind of come about what parity was and what that meant. I think there was questions when the number came out because what some attorneys were making, because positions were consolidated, it kind of gave a false sense of what the salaries were. And so when we saw that number, because the conversation to us was, hey, district, there's ADAs are getting under public defenders. That's how this was brought and began the conversation. But it wasn't really until last week, I think, that the director's staff sat with Anna and really went through, here's what step in class, and here's how much it is to catch up each step in class and to figure out if all positions are filled where that money came from. But there was a gap in comprehension on our side and communication on the other side for us to really understand that is. But to your point, the importance of pay parity for us is so much so that in the amended budget we gave pay parity starting in April. So it wasn't given by the governor. Maybe it was asked for, but it didn't come to us that way. That's something that we added. So starting April 1st, there is that. And so this is important to us to continue from a policy standpoint and from a position standpoint. So I appreciate you being here. That number is still staggering. I think part of it was just masked in the way that things are kind of presented to us and really from a consolidation of positions. So I appreciate you. I don't have any questions, but we do have some from the committee. Whit Park.
Thank you, Mr. Chairman. I appreciate, the request and the importance of parity. I did have a chance to review the audit done, I think a year or so ago, which certainly had a lot of concerning findings. With respect to discrepancies, 44% of state-funded attorney salaries exceeding maximum limits set by the Department of Audit's DOAS. My question is, in light of these concerns, has there been a formal salary schedule adopted as required by Georgia law?
Hey, Representative, I don't know if I recognized you when I went around. If I did, okay, I was like, okay, that's a little bit of a maybe senior moment for a minute. So that's why we were working so hard on the common pay plan, so that we can have something that speaks to what everyone makes, and so we can have a standardized pay plan for everyone.
So y'all have adopted formally a pay schedule that is compliant with Georgia law? That's a...
What we have is going to be along with what PAC has. That both of us, we have the same pay schedule.
So members on this body in a bipartisan manner have demonstrated that we also care about parity and certainly in the amended fiscal budget, by
Yes, sir.
ensuring that millions of dollars were appropriated for purposes of parity.
Yes, sir.
I think as we're going forward,
Yes.
to ensure that we are addressing some of the discrepancies, very concerning discrepancies that are alarming to me, that as we continue to proceed with ensuring parity for both public defenders as well as for prosecutors, that again that GPDC is also ensuring that internally, right, that there is a formal salary schedule adopted as required by Georgia law that again can ensure that that is in parity with prosecutors as we move forward. I don't think with members on this body in a bipartisan manner you will find any real objections in terms of appropriations for parity. We want to see that. I think it's good public policy. But I think internally we want to ensure that we don't continue to see these discrepancies in which when requests for information are also provided that we don't know where the money's going. Because of course this is not just a one-time appropriation. Going forward we want to continue to ensure that your agency,
GPDC.
thank you, that y'all are receiving the requisite appropriations for purposes of parity. But again, that requires that we have a salary schedule that has been formally adopted, that we are complying with Georgia law, and that what information is being requested by the chair, who provides to all of us, that we have that ability to ensure oversight and transparency, and especially in light of the findings that were recent. So.
Okay. We will continue to provide you everything that we have so that you know, representative, we have a hybrid system, a county and the state. And so what we're attempting to do now is have a set scale that's hopefully going to be codified, and then that will become law. And that hopefully in the future will address all of our salaries. And that's what we're hoping for.
So is there existing law, OCGA 171230, that requires GPDC to adopt a formal salary schedule without any further legislation? Has that been done? That is my question.
That's what we're trying to do now, to make sure that we have a pay schedule that now is going to be in conformance with what PAC is doing.
Okay, thank you.
I hope I'm answering your question.
Thank you.
Yeah.
Thank you. Okay, Chairman Gunner.
Thank you, Mr. Chairman. The numbers that concern me is the loss of ARPA funds that you're wanting to replace. How many cases does that cover? How old are those cases? And is this private attorneys or is it other attorneys in your
Okay, so we provided some kind of tracking sheet to you all. I don't know if you have received it because that question requires a lot of numbers. I have that here today, which I can provide to you. So maybe that will, because I can go, that's a lot of numbers, and I can provide that to you. Because that's different circuits, different numbers, as you must know.
Answer that
Yes, sir.
here. I'm all ears.
Yes, sir. So it's not something I have to go circuit by circuit, and I think it may be necessary to look at those numbers first before we can answer those questions. But I did bring that prepared for you to look at it first.
Here, we'll give you a second to look at that, Chairman Gunner. Come right back to you if that's okay.
Okay.
Representative Evans?
Thank you, Mr. Chairman. Following up on Representative Park's question, I'm having a hard time understanding why we don't have the schedule, because I don't know how you could come up with the number that you need for parity if you haven't done that schedule.
So what happened over the summer, and working with the chairman and all of you, is that we went through, we used as an example, as a template, what the prosecutors have. We're using them as our template, and we, if you remember, we collected all our resumes for all our public defenders and went through line by line the number of years they have worked and put it on the template on that schedule to make sure that we're following what the prosecutors are doing. That's how we came up with that number during the summer.
Okay,
So-
and yeah, I remember very
Yes,
well. It was a lot of time that we spent this summer,
Yes.
which is another example I know that's been expressed about how important parity is to this committee. No one has to convince us of parity,
Yes, ma'am.
but we do need to see where the money's going. And so, I mean, it sounds like the answer to the question is yes, you have one. And so I don't know why we don't just have it. So maybe that could be something that could be quick homework. Someone back at the office could get it over to us. I think it would make us feel a lot better about the numbers because we want to do this. I mean, we really, really, really want to do. We spent our summer getting to this point. And so it sounds like to me the answer to the question is yes. And I'm just asking if you could please send us that schedule.
So we
Whatever you call it,
Yes, ma'am.
however you got to it,
Yes, ma'am.
just send it to us.
Okay, I will. And we
Okay.
never had one since I got this job. And we embarked on the efforts to get one, working with the prosecutors, but we needed the chairman, and when he got involved in it, it actually got traction. There is a story behind that, but I don't think that's the story you're asking me, but it did take about 3 years
No, we
for us
just,
to get to this point.
definitely, we just need it. And I think it's important so that we don't have to go through this again.
No,
I
as soon
think
as,
if we don't have it, we're gonna be back here again in a year, and I don't think anybody wants that.
yes, ma'am. And I agree with you. Once we have this schedule and it is codified, we will not be doing this back and forth. As you must remember, we have the HB 1391, and we're not going to be doing back and forth because it's already codified. We know this is the law, and we don't have to say, well, what is the law? What happened last year? We already know where we are, and that's where we have to do, because all the work that was put into this during the summer should not go to waste. And this is actually a culmination of efforts about 4 years. And we thank all of you for getting us together to make sure that this is done. So its codification is will make sure that this does not become a wasted effort.
And I'll go a step further than that. I will say that PAC has a schedule that they provide us today, and we want parity to happen. And if we don't get the schedule, I don't think we can give this money. So we need it. I think that's that important.
Yes. We're following their schedule. It's the same schedule all the way.
Yeah, we just need you to print it out and give it to us. We're going to match it up against the PAC.
Okay, that was what we came up over the summer, working with you
Yep.
and all the other members, and
Yeah.
we have provided it, but I can provide it again.
Yeah,
It's the
we
same
need-
exact
That was this
schedule.
summer, though. We need it provided for this meeting, for this group right now,
Okay.
and it needs to be into the record as this is where we are today from a parity and that we are aligned today. And I really feel like, honestly, you don't need a separate schedule. We should say almost whatever PAC schedule for true parity, whatever PAC schedule is published, that's y'all's schedule too, and that's the way we're going to get there. But I want to see what you have for your schedule, and if it aligns, then we'll work through that. But we need you to provide what that schedule is so that we can say $7,847,602, if my eyesight's not terrible, is the right amount that gets you that parity.
We'll provide it to you, sir, but it's the same exact one that we all agreed upon during the summer. It's the same. It's just, I can get their schedule and copy it for you. It will be the exact same one, but we can
Perfect. So-
copy one and just
Wh-
put our name on it.
Which class and step is this as far as like, so the district attorneys have a three-year process in order to raise their staff's pay. Which, is this the year one? Would this
Yes, sir.
align with year one for district attorneys? So if they don't get a pay increase this time, this is what levels you out. This is not step two, with that, correct?
It's the same exact level, and I think I assured you that we have employees who may be above that level, that we will redline and grandfather them into where they are until they get above that level. So it's the exact same level. I think when I started this conversation with you, it was important that we all be on the same schedule, and we went along and got on their schedule. It's the same exact one.
Thank you.
Yes, sir.
All right, Chairman Gunner, back to you.
All right, thank you. All right, so Tell me about the difference between contractors and your regular frontline assistant public defenders.
So, can I get you, Mr. Berry, to answer that question?
Good afternoon, Mr. Chairman, ladies and gentlemen. I am DeAndre Berry. The difference is the regular line employees are full-time assistant public defenders. The contractors are monthly attorneys, attorneys that accept contracts for a specific number of cases. They are private attorneys that accept cases.
Okay. And are they in and out of the system, or are these like regular contractors that you hire to represent the public defenders when there's a conflict, or represent the defendants when there's a conflict?
These are private attorneys that accept conflict cases. Yes, sir.
Okay, but do you have a list of them, or is that a constantly changing?
Do we have a list? Yes, sir, we have a list of them. Yes, sir.
Okay.
And there are 125 contractors right now, sir.
And you have the numbers on how much you pay those folks?
Yes, the amount is, it's 100. Each attorney has 100 cases for how much? 100. Yes, 100,000. Yes. Want to be
sorry,
exact.
for how much?
$100,000 for 100 cases per year.
So it's $10,000 per case they get?
$1,000 per case. Yes.
Okay. I used to be good at math. I'm not anymore. All right. And the hybrid defender system that you have.
I'm sorry.
The hybrid defender system. This is, when I was a DA, I had state-paid assistant DAs and I had county-paid assistant DAs. Is that kind of what y'all are talking about?
Yes.
Okay. Because I operated out of 6 different budgets, one for each county in my circuit,
Mm-hmm.
and anyway, the others. So the ones for each county was where I had a assistant public or assistant DAs. Is that the same that y'all are having with public defenders?
We have contractors throughout the state. In some areas, in some of the legal deserts, we're having more challenges trying to attract those contractors, but we have contractors all throughout the state, sir.
So, but do you have a separate full-time assistant public defender paid for by the circuit?
Yes.
You do? Okay.
Yes, of course.
And you have all those numbers?
We have, yes, ma'am. Yes, sir.
And are they at parity with assistant public defenders from the state?
No.
How
no.
far back are they? It
Terry?
depends on the circuit, I would imagine.
That depends on the county. It depends on the county and the location where they are.
Okay.
Yeah. In some counties, they actually make more than the state employees. In some counties, they make way less than the county employees. It depends.
Okay. All right. Understand. Thank you.
Yes, sir.
Whip Park.
Thank you, Mr. Chairman. So just without a doubt in my mind, I know that your agency is following Georgia law to the letter, to the T, right? With respect to especially these salary schedules, which per subsection C1 of the code section I cited earlier, would be adopted pursuant to the rules of the State Personnel Board without regard to any parity. So as a starting point, right? So I think what this committee is wanting to see is a salary schedule required by law to be first adopted to ensure that we can then move toward parity with prosecutors. At least my understanding of Georgia law. I don't know what the study committees or what conversations were had, but with respect to, again, ensuring a salary schedule adopted in compliance with Georgia law. I think that's the first, at least, step in which I would like to see, right? Second, with respect to, ARPA funds, I'm certainly not as learned as the judge, nor do I have the experience with respect to, these sorts of cases. However, I'm not aware of any other area, within the purview of the Appropriations Committee in which we are replacing state funds for federal funds that were never meant to continue in the long term. So, no doubt, we've seen greater complexity with respect to conflict cases. I think my question is, what is the transition plan to address this increase in conflict cases such that we're not relying on either federal ARPA funds, but that this is ultimately, being transitioned into this movement toward parity for both public defenders and prosecutors.
So it's going to require state funds.
And,
So,
and
as
$6 million a year is what you're anticipating is
well, so and that's what I was hoping that Ms. Deland, who's one of the public defenders, would address. As long as we have the indictments coming in, we don't indict the cases, but we have the commitment to make sure that we process the cases irrespective of where they're coming from. We have the constitutional commitment to make sure that our clients, wherever they're coming from, irrespective of how many numbers on an indictment, we have to process. As long as the indictments are coming in, be it from jail fights, RICO, and gang, we have to process. Over the years, the complexities have increased. Over the years, the indictments have increased. Over the years, because of COVID, we have such a backlog. As long as those indictments are coming in, we will need the funding. It's like an insurance, pay now or pay later. And we want to pay now so we can avoid the gridlock in the courts. And so I bring someone here to kind of address it from the perspective of someone who sees it in the courtroom on the daily basis. I'm not in the courtroom. I was there for 17 years. I can tell you if we don't address it now, we'll pay later. It's going to be another gridlock. It's going to be another litigation, and we want to avoid all of that. But as long as the indictments are coming in, which we're not responsible for, we will have to keep processing the cases.
I think with respect to, I'll speak for myself, but I think my understanding as to the members on this body is that we want to equip you
Yes, sir.
and your department with the resources needed to address this
Yes.
and ensure that the law is followed again to the T, certainly when we're talking about prosecutors and public defenders.
Yes, sir.
Again, I suppose my question to that regard would be, have you provided all data with respect to conflict requested by the chair and his team to ensure that they have full faith and confidence that the request being asked matches what the data is being demonstrated, not just what we are saying in terms of anecdote, but in terms of something that we can again exercise our oversight responsibilities as steward of taxpayer dollars.
Indeed.
Representative, I hope we have. If we have not, any additional information that you would request, we will definitely provide it to you, and we will try our best to provide it, if anything that you ask, by the close of business today, if we can do it today.
Thank you, sir.
Yes, sir.
Good afternoon, and thank you for having us here to speak before you today. My name again is Letitia Deland. I'm the Circuit Public Defender in DeKalb County. And to answer one of your questions, Judge, we have 73 attorneys in our office. Only 3 of them are state paid, so the rest are county. 4 including me. The rest are state paid. In DeKalb County, we're lucky that we have pay parity with the DA's office on a county level, and our county salaries are much higher than our state salaries. So I'm very fortunate for that. And appreciate the work that went into making this pay parity a reality for our assistants. In terms of the conflicts, and I will try to explain this in a way that makes sense. As many of you know, this is a situation that has ballooned. And I know we've been asked why all of a sudden there are far more cases that are requiring us to declare conflicts. We are seeing a lot more RICO cases. We're seeing a lot more gang cases. In DeKalb County, we're seeing a lot of jail fight cases. And that stems, I think, from COVID era where they were people were not getting out of jail. People were in lockdown because of COVID. So certain pods were in lockdown 24/7. They're frustrated, they're angry, they're in a place they don't want to be, and they're getting in fights. We regularly see, on a, I would say, weekly basis, we see at least one jail fight case come through. And it might involve 6, 7, up to 10 inmates. We represent, in all likelihood, all 10 of those people. And so now we have to parse out, okay, we clearly can't represent the alleged victim of this fight and represent all the people that were accused of attacking him. So do we keep the victim and parse out these 10 cases? Can we keep some of the 10 and get rid of that? So it's a thought process that we have to go through, and we do go through, but the law requires us to hand out some of those cases. Our office cannot represent them. That's not something we can do anything about. We're obligated to provide representation to people. In terms of the money, and I think it was Representative Park's question about the ARPA funds and how we used those funds and now are asking the state for those funds. I think that if we had not had the ARPA funds, we would have been before this committee asking for that money to dig us out of a hole. I don't know where this will end. I don't know if and when these cases will stop coming, but as long as they're coming, we need the funds to pay for them. I'm happy to answer any questions you might have.
Sure.
Thank you, Mr. Chairman. As I'm looking through this sheet that y'all provided, I'm looking at conflict cases out of total number of cases. Can you help me understand just kind of why there's so much variance in which, I see DeKalb County, 5% of their cases are conflict cases, whereas in Cordell, Appalachian, we're looking at 50% of conflict cases being total cases.
Mm-hmm.
Can you help me better understand that variance?
So I think from a CPD perspective, I am a little on the OCD side about going through these conflicts and looking at every single one that comes across my desk and asking my attorneys questions, which I'm sure annoys them because they send me a conflict request and my response is almost always, I understand they're co-defendants, but why is there a conflict? I can't say that all of the CPDs do that. They might, I don't know. I can tell you that's my practice. I think also part of the problem is that I have a large office, and so some conflicts that might otherwise have to be farmed out, I can absorb in my office because it's so big. I can have somebody from my state court team maybe handle a superior court case if it's a conflict that can be waived. And smaller offices can't do that because they don't have the staff to do it. So that's one part of the answer. There may be some additional responses.
One final question, if I
Sure.
may. Would a uniform practice or procedure with sorting out conflict cases help address some of this very large variance, at least not taking into consideration, the resources that y'all have been provided by your county government to ensure that these cases could be absorbed?
Yes, and we are working on that now. We are in the process of doing a pilot program with my office and one or two other offices throughout the state to try and come up with a way to make this run more smoothly, providing a training for the CPDs to make sure we're all on the same page in terms of what a conflict is, what a conflict isn't, where there's wiggle room, where there isn't.
Thank
So
you.
yes, we are working on that.
Thank you. Representative Evans?
Thank you, Mr. Chairman. Representative Park and I were on the same wavelength here. My math is not great, that's why I'm a lawyer, but I was able to go through here, and 13 out of 45 of the circuits listed, it looks like about a quarter of the cases are conflict cases. And I'm not saying that's not possible. I am saying it's concerning, and what I worry about, and it's, we have to shoulder the blame as much as anybody, but perhaps because the ARPA funds were flowing, no one was concerned about how much the conflicts were growing. But I do think whether it's some sort of state panel that looks at a uniform standard on conflicts, or just some other way, this just can't continue. And I know at the last meeting we also talked about maybe we need to discuss whether certainly if someone is injured, or certainly if someone dies, certainly those cases are important. We want justice for the victims. But at the same time, does every jail fight need to be indicted? And I know that's not a question for y'all, that's a question for the DAs, but it just seems like this is to a point where it's unsustainable. And it's a broader question than what we can deal with today or even this session. But maybe our next summer project is taking a look at what different circuits, what's coming in and how they're determining if there's a conflict or not. And it may be a good starting place is if we could have gathered, I don't know how difficult this would be, but if it isn't too much, I would think it's written somewhere already, what does each circuit have written as far as their conflict policy, so that we could at least see that. Maybe we can start there, and then we can start thinking of potential legislative solutions or put y'all in the room with the DAs. But this, to me, just can't continue. It's unsustainable.
So to your point, and to Mr. Lawrence, we are working on a new policy and protocols. We have picked 2 offices that we're going to use as pilot, and we all should be meeting very soon, I think in the next week, to come up with the policies that you're talking about, and hopefully we'll be able to have that conversation with you very soon.
Okay, well, maybe just as a start, if we could just ask that questions to the circuits, what are you using right now? I think that would be, before you could write a new policy, or before we could see if it's the policy or if it's something else. That seems like a good starting place, if we could just gather that information.
I do have a quick question, and we're going to go to you, Chairman Gunner. Of the conflict cases we have, I did look at a chart you guys sent. It didn't look like it was, it was since 2020 maybe, so maybe already the ARPA money was flowing at that point, somewhere around there. But how many conflicts, what percentage of these conflicts are conflicts because it's an appeal and it's automatically conflicted out versus multi-defendant conflicts?
That I cannot answer right here. I can guess, but I cannot answer, and then I don't want to be wrong.
Speak to me in high. I don't need a number, a specific. Is 50% of, you think 50% of these cases are likely appeal, automatic conflict on an appeal, or something multi-defendant? 80%?
I think most of them are multi-defendants, really. Right? Yeah. Yeah, higher percentage is multi-defendant.
Okay. Yeah. Chairman Gunner.
Thank you, Mr. Chairman. All right, so my recollection of your budgets, since I've been looking at them when I first came down here in 2021, the first year was a $2 million guess at how much it was going to cost you for conflict counsel. That's what I remember in that budget, because it almost got cut out. That's why I remember it. And it seems like the next years it kept growing. Here, I don't see where you have a request for conflict counsel. You're trying to replace ARPA funds that you were using for conflict counsel, and I don't see where the regular money that you would ask for in the budget. So can you help me out there?
Are you referring to the 3 regional conflict offices that we received $2 million for? Those were to create additional offices.
This was 5 years ago, and it was $2 million that y'all asked for.
Yeah, that was the regional conflict offices to hire employees.
So tell me, what's the difference of what goes on there versus the ARPA funds going to conflict counsel?
So if I remember correctly, when I first came, there was the issue of legal deserts where we could not find attorneys in some of our areas. So we thought it was prudent to just create offices in those areas so we can take services to where people are, and we will not be telling judges we couldn't find folks. And so we went about creating offices in some of those legal deserts or closer to them so that we can dispatch attorneys. And that was the $2 million to create those offices and hire attorneys into those offices, if I remember correctly. So that's what the $2 million was.
Okay.
Yes, sir.
So how much is that money now?
It won't be anything now because we created the offices and we staffed them. It will be a one-time fee. We should not be asking for anything for those offices now. They were created and they were staffed.
So the attorneys at these conflict counsels offices are not assistant public defenders in the circuits. Is that correct?
Most of them are assistant public defenders. So we have a hybrid of those. We have some that are permanent employees so that we can have some staff on hand for when we have those cases. But the rest of them, because there are so many multi-defendant cases, those are the contractors that you see, or when we have just a whole number of cases. So, but the $2 million was to create offices and to staff those offices at that time. So it should be a one-time.
It's not $2 million today.
I think
correct?
it was $2 million.
So it was 2023, it's $2 million, but it's annualized. So we're still giving them $2 million. It's just not a new request. It's just part of the annual
Okay.
Yes.
money now, if that helps you.
I understand that. Okay, thank you.
Any other questions from the committee? Number 5, there you go. Representative Ballard.
Thank you, Mr. Chairman. I know you've talked about deserts where there's not any attorneys. So I'm assuming some of these folks have to travel. Do they get paid mileage?
Yes, ma'am.
Is that rolled into your number that you're asking for?
Yes, ma'am.
And can we get a ballpark of
How much?
that number?
We can. We pay them mileage, and sometimes we have to pay them accommodation because they have to stay in that area.
I think that the committee would probably like to see that number
Yes, ma'am.
as well.
Yes, ma'am.
I do have a separate question. Currently, you're in the executive branch, and I know there's a little history there of how you got there. Do you think it makes sense to consider this going back in the judicial branch?
That's beyond my pay grade at this point, sir. I think that needs a bigger conversation. I don't know that is. I think that needs a bigger conversation, sir.
Okay, fair. All right. Any other questions from the committee? It sounds like there's a little homework that we were asking that you do, especially on the job grades, and we want to help you. Especially on the pay period. That really is important to this committee. We spend a lot of time. You spend a lot of time on this. PAC spent a lot of time on this. We want that to be successful and to happen.
Yes, sir.
I think ARPA money and the conflict cases is just hard for us to get there sometimes with what we know and just how the way we think about things and what you guys are doing and how. And honestly, I'm still trying to get my mind around you saying earlier you think most of those are multi-defendant cases and not appeals cases. That very well may be true, and I don't practice law, but it just doesn't go with what I would think would be the case. So I'm looking to see that data if you could provide that too.
Yes, sir.
Okay, don't like you have any more questions. Appreciate you being here. Thank you.
Thank you so much.
All right, thank you all. Let's see who's next on the list. Judicial Council and AOC. Floor is yours. Thanks for being here.
Thank you, Mr. Chairman. I'm Charlie Bethel, and I have the privilege of chairing the Judicial Council's Budget Committee. And so I come to you to present all in your Section 6. I will try to follow in order on the line numbers, but just to remind the members of the committee, we do have a couple of parts of Section 6 that administratively fall under the Judicial Council, but you hear them as separate presentations. So I will start at 6.2, which is the Georgia Office of Dispute Resolution. There are two requests under the Georgia Office of Dispute Resolution this year. 6.2.1 is for the Schedule ADR Case Management System. That is a system that the office currently uses. That is the annual cost of the system being used. Since 2011, the Office of Dispute Resolution had a history of being funded with state dollars. 2011, the transition was made to funding it exclusively through primarily the neutral registration fees. That is to say, it doesn't get a state allocation in 2011. Since 2004, referrals to ADR systems in Georgia have more than doubled, and the number of courts that are being served, we're in 111 counties with formal programs, 37 court ADR programs. The number is less for those that use the Schedule ADR system because some of those courts use their own scheduling system. So it's 26 different court programs that use the Schedule ADR. But this is a request to move that sort of fixed cost of the system back into the state budget. And that comes in partnership, but it's not essential that it be connected to the secondary request, which is a request for a program coordinator. This is essentially a request because of the expansive growth in demand to have an individual who takes pressure off the executive director and deputy director who have continued to see their caseload expand, but there's not been a staffing support for it. So this is an administrative role that would step down from that, and that's the nature of that request. I do have with me, to the extent that the committee has questions about the operations of the Office of Dispute Resolution, I think Judge Markham is here, who's the incoming chair of that commission, and then Tracy Johnson, who's the executive director. If you've got operational questions, obviously this falls within their bailiwick, but that is the nature of the request.
I do have a couple questions on that one. Are you trying to annualize that 78,000, or is that something at one time, like a?
So it would be annualized. That is to say, the request is for the state to take over funding that Schedule ADR program.
And we have a big, beautiful $168 million case system out there. Why can't this become part of that?
As a non-technical expert, I'm under the belief that it can, and there are already conversations around allowing the Georgia case management system to integrate into the Schedule ADR. Now, then the question does become, I think everybody has to understand what's happening. The system that is being built, and I'm going to talk about that in one of your other lines, is voluntary to the court's participation. And so to access it and use it for your ADR program, presumably you would have to be a jurisdiction that's participating in the CMS.
And you can't participate in parts of it, not all of it?
I am not qualified to.
I would think that we could figure that out.
I suspect, my suspicion is yes, but I'm not qualified to say yes.
Yeah. I'm qualified to say we're going to figure that out, I think.
Okay.
Would you be opposed if we did a one-time while we figure that out and make that not annualize that?
We would welcome whatever the legislature thinks is the appropriate way of addressing it. It is literally just a request to free up that fixed cost into more delivery of services, because that's the cost. But if that's what the committee and the General Assembly thinks, obviously we welcome the support and whatever you think is appropriate.
Okay, thank you. You can continue. Let's see more questions.
Yeah, okay. I will then turn, if there's no questions on the program coordinator piece, to your section 6.3. This is the Institute of Continuing Judicial Education. There is a request, just a singular request, for one accounting paraprofessional position. Since its inception, the Institute for Continuing Judicial Education has had one financial administrative person, one role. I mean, it hadn't been the same person the whole time. And they now serve, I think, 4,800 roughly different clients, and that, your constituents, I guess is what they call them, but that is a dynamic expansion of the demand. And so we have an individual who is responsible for all of the financial intake, and they're doing that alone. We don't have any specific cause for concern, but the auditors suggest that it helps to have a second set of eyes within a fiscal operation of that sort. And it also would allow just basic office management tasks to be moved into a position that can serve, again, just we have way more judges than we did, and I apologize, I meant to write down the year the ICJE was created, and I didn't. But this is just the growth of the number of people they're serving and working to educate is the nature of the request. Okay. If you have questions about that,
we'll interject on you.
Sure. Okay. Turning now to your section 6.4, which is the Judicial Council proper. 6.4.1 is really just is an annualization of an adjustment that the General Assembly did last year for recruitment and retention compensation pieces that just started in January 1 of this year. So that was a mid-year adjustment, and that's an annualization. Obviously, I'll answer questions if you have them, but it's straightforward from what you did January 1. The second request is the one we've already sort of touched on a little bit, which is 6.4.2 is increase of funds for personnel for the continuity, really the operations of the Georgia CMS project. That is 8 positions. That is a request of $586,649. That is for half of the fiscal year. I want to be transparent about that. So for those 8 positions, that would anticipate the same number coming next year. That reflects the current staffing level of the project as it stands today. You are all familiar with the fact that the governor allocated ARPA funds and asked the judiciary to sort of take responsibility for standing up the statewide CMS, and then Chief Justice Boggs sort of took that on, and we have built the system. It is now in the testing and rollout phase, but the funds, the ARPA funds that the governor appropriated or allocated, I guess is the right way since it didn't come through the budgeting process, concluded on the last day of this calendar year, so halfway through the fiscal year 27. So this is to stand up the whole project. This, I will note, what I've referred to it with my own team, with our own staff, is that this is the maximum funding request. One of the things, as you've pointed out, is as we bring pieces, and we bring different jurisdictions on, as we bring pieces of it live, there is necessarily the opportunity to recapture revenue, and our what we have to evaluate is what's the appropriate place to price that with the users of the system, and then also I think I've told the chairman offline the exact precise way for us to account for those dollars when we bring them in, whether they come in through our budget or whether they come back into the general fund. I mean, at the end of the day, money's money, but where it shows up on the budget is important, and we are exploring both of those things as we now have a finished product or a finishing product that we're out there on. But again, I can walk through the 8 positions if the committee likes, but that would not reflect an expansion of staff. That would be the operations that we have today.
I do have a question about the case management system in general. I know in the amended budget, we allocated $150,000 for an accountability court hook.
Yes.
I think I was watching a hearing where it said you don't need that money.
So
yeah, can you tell me a little bit about that?
So I I have been reaching out to different entities to try to determine the origin of that request. It is true, and we have talked about the ability to have Hook for accountability courts and some other, other places to access the system. My understanding from talking with staff is that we have accommodated all outstanding requests within the dollars that were allocated, the ARPA dollars that were allocated, that we don't have anyone out there saying, I don't have access to the system because there's not enough resource for it. If that's not the case, obviously we would be open to a conversation if the General Assembly wants that access to be available. But I am, as I stand here, not aware of an actual open request, if that makes sense, that has been deferred because, well, we don't have the money to do it. And so our position in conversation with everyone is we obviously want to partner and be available to anyone who wants to connect. But if you have requested from us an attachment and we've said no, then that's something that we need to address and we need to figure it out. But my understanding is that everyone who has asked for accommodation has been accommodated within the dollars that are already in the project. And that was the only reason, is that I didn't know that I don't know what we would spend it on if we had already addressed all the requests.
Okay. Yeah, we can talk offline.
Sure.
I think there is a request, and the reason that the request was put in was because it wasn't already in the pipeline of what was the scope of what it was, and that was to make this new scope of the application.
Okay.
I know conversations happened with staff over there, and I'm pretty sure that they understood what the goal was, but I'm not too heartbroken over it. I'm just trying to understand, is our accountability court's going to have the ability to, accountability court's going to have the ability to hook into the system. That's really the gist. That's the importance to me on that.
And Chairman, that is my interest as well. I mean, I think that's the collective interest of everybody that's been a part of the project. And I will say here, I know I'm sure that millions are watching online. If there is someone interested in the project that feels like they have asked for an access point, I would certainly welcome hearing from them. I have heard from no one that has told me they haven't had access.
Okay. You do have a question, Whit Park.
Thank you, Mr. Chairman. So just with respect to the Georgia Case Management System, this is still in the pilot phase of the program. When do we expect that the state would no longer need to provide additional appropriations? And with respect to the pilot and the timing of it all, is it all on track? Everything is working well and moving in the right direction?
Yeah, thank you, Representative. The answer to the question is, I'll start from the back and work forward. We are on track. We are continuing to roll it out as on schedule, as planned. The answer to the question of when we will be able to sort of reverse some of the appropriations request for funding it is primarily going to depend on the rate of adoption. So as courts and functionality is adopted and we find a revenue associated with that, then obviously that offsets it. But I don't have a way of predicting, and we don't have any announced intention, and I don't think the General Assembly to date has announced any intention to require folks. I think as a practical matter, when the system is functioning, it's really difficult for me, notwithstanding all of the other interests. We are very confident that from a financial standpoint, it will be to the benefit of jurisdictions to join the Georgia system. But even if that weren't true, a system that allows judges sitting on the bench, temporary protective system would be integrated and connected. It's hard for me to imagine from a public safety standpoint that the resistance would last long, but I have been wrong about so many things that I expected to happen in government in my life. I wouldn't bet on it to the extent I was a gambler. But so that's the real question: is how quickly and how expansively we can ramp it up and roll it out. And I'm hopeful, but experience, optimism may be more expensive than hope in that space.
I clearly see that and understand the benefit and need, and I am comparing apples and oranges here, but for legislators and the state ethics filing system, in which we've had to do that for a few years, we're moving to a new system, the platform seems to have ongoing challenges. I just want to ensure that, especially given how important and beneficial the system would be, that there's not this sort of open-ended, constantly tweaking sort of situation going on with this new system.
It's the worst thing to say. You feel good about an ongoing project, but I think that my sense in conversation is that the front-end investment that was made on looking at peer states and sister states that have created similar projects in the recent past, and there was a lot of planning, and I will say then Chief Justice Boggs was at the table for a lot of those conversations to try and make sure that we don't create something that has problems, greater than what the existing legacy systems have out there. I'm optimistic by nature, but I'm optimistic that we will have created a product that provides value to every court.
Thank you. Representative Kelly, you good?
Thank you, Mr. Chairman. Mr. Justice, thank you for being here with us. I share Whip Park's concerns about how long we're going to have to continue to fund what I recognize as at least partially redundant case management system, because I feel like at least on the civil side we have a great system in place that's working now. And I'm trying to make sure I didn't misunderstand what was being said. Are our two options to fund the Judicial Council's case management system, which does include some good things, especially on the criminal side, that we haven't got addressed in Georgia. But as part of that, we're either going to fund it through state appropriations ongoing, and we don't know when they'll stop, or until we essentially create a product that has put currently existing case management systems that may exist here in Georgia that are working on the civil side now out of business, so that everyone will use the Judicial Council's case management system?
I don't think that's an either or proposition. And again, unless someone takes the position of sort of mandating it, and I'm not aware that anybody has. So I think as a practical matter, in terms of recognizing the capacity to fund and provide a revenue stream to support the operations, the overwhelming majority of the dollars in these systems is in the civil side, because you don't charge a criminal defendant for having a case. They don't usually have a say in the matter. And so that is where the revenue side of the operation is going to exist in any case management system. And that's sort of true in the legacy systems that are piecemealed around the state today, is that's how they're financed. They're just financed at the county level, that it's the civil side that drives the financial wheel. Now, the system itself can be operated, I would imagine, in different jurisdictions within different parts of the court system, but the cost of operating it should not be materially different based on how many courts and whether it's criminal or civil courts that are participating. As I understand the operation, you're creating a system and operating that system, and I'm sure there's cost and demand based on volume, but at the end of the day, building it to be able to serve all of those courts is what's being constructed and being maintained. Now, the other thing that I'll say, in addition to court adoption, that my team may get tired of listening to me coming out of the manufacturing world, is we have systems that we're doing, things that we're doing today, and the chair sort of talked about it from Schedule ADR and those sorts of things. We have things that we should be actively trying to migrate onto this system, and we ought to be able to realize savings from those. I don't have a number, but it will be dependent upon once this system is standing and operating, that you then start saying, can this system handle this piece that we're doing a la carte for various different other functions and bring it into one system? They're not going to stop having me ask that question until we have a clear picture that we're not running from our standpoint, duplicitous services.
If I could follow up, Mr. Chairman. Is it your belief or the court's belief that y'all have the authority to mandate the use of a judicial council case management system?
I certainly won't speak for the court because we have not spoken about it. I mean, this is not that question has not been something the court has considered. Whether I believe that, I would have to sit down and I don't really have an informed opinion about whether I believe that we could. It has not been my experience on the court since I've been on it. It's now my 8th year, which is staggering to me, but that our court is all that interested in sort of mandating and pushing out into other areas. We really like to try to cooperate and work in cooperation. And again, I sort of refer back to what Representative Park's question of I'm still a believer that if you have something that works, that provides value and increases public safety and confidence of judges on the bench, it is an inevitability, because why would you choose a system that left judges blind to the information that is available? That doesn't make sense to me. So it feels like to me that we're better off when we work together and we explain to people why the system is a better model and would have been what we would have created from the beginning if we had the resources to do it.
And I do appreciate the relationship this legislative body has with the court and the way we do work together here. I guess what I'm hearing is we have a problem today on the criminal side. At least as a civil attorney, I don't feel we have a problem on the civil side outside of we've ran out of ARPA funds now and we're trying to plug a hole. Now, I appreciate y'all aren't necessarily looking like our previous presenter to just backfill federal dollars that have flowed down just with a huge appropriation every year, looking at some other ways to do it. But I do feel like we are trying to solve a problem that I recognize does exist on the backs of people who don't have a problem today.
And I appreciate that, Representative. I mean, I certainly value your perspective as a practitioner in the space. I will say, I mean, they are certainly not of the magnitude of you would see on the criminal side, definitely. But things like the ability to file a notice of leave and have it be effective in every jurisdiction. I've had a lot of civil litigators say that would be helpful to be able to have that sort of a one platform place that then reached out to all of the courts where you're practicing and representing. And again, some of that depends on how many jurisdictions you're actively practicing in. But there are, I think, valuable aspects of having a unified system. And of course, not all of our criminal justice world, meaning juvenile court and some other aspects are in the criminal docket. They exist in the civil space as well. And so, I mean, there are functions that would tie in there. But I mean, I certainly respect your personal experience and practice experience too.
Thank you.
Okay, any other questions about that? I'll just make one quick statement. I do want to make sure that we're cognizant that these businesses who do the civil filings are Georgia-based businesses, and tax dollars are being used basically to compete with those businesses. We'll figure that out as we go. It's just I'm sure that happens often. It's just one to consider as we go forward.
It is, Mr. Chairman, definitely. And we were thankful to receive bids from a lot of the Georgia-based businesses, I think, in the process of bidding out the project, who had interest in it. Okay, 6.4.3, increase funds for the civil legal services for families of indigent patients. This is the medical legal partnership project that we've been undertaking for several years. The legislature has been very supportive of it. The returns for the dollars spent we feel very good about, but I am in a position this year to actually ask you not to provide us that number. And the reason is not that we don't think that that's a worthy investment. It's that we have encountered difficulty in finding attorneys to staff the function. And so while we are not fully utilizing the resources you appropriated to us now, I'm not going to ask you to give me more. We believe very much in the project. We feel like we've taken some steps to address the rollout and engaging with our partners that actually deliver the services in this space, that we feel good, and we've actually started some new conversations around ways we can more efficiently ensure that the funds that you appropriate in this space maximize their utilization and therefore their return. But for those of you who may not have heard of medical legal partnerships, this is a model where you embed an attorney. We generally have partnered with Atlanta Legal Aid and Georgia Legal Services in a healthcare hospital sort of setting, and they provide legal services to indigent users of the healthcare system. And the savings both to the state and often to the healthcare system are pretty substantial because it allows that person to access whatever legal resource. Again, the spectrum of services they provide is very broad, but it allows them sometimes to get out of the hospital, depending on what their condition is. And so we're very confident in the project. We just don't want to ask you for dollars on top at this point until we are comfortable that we're using them.
I don't know if I remember correctly or not. My wife tells me I don't often. So last year, you said the same thing basically last year, right?
I did.
Okay.
So our challenge has been mainly outside the metro area. It has been difficult for us to get consistently secured positions. And so we're evaluating some different strategies around how we might be able to maybe get some other partners to the table as far as how to do that. We have the original pitch that predates me for this project, as I understood it, was that we would try to balance those resources between the metropolitan area and the balance of the state. And in an effort to try to do that, which is what we sort of stayed true to that original initiative, we have found that it is proven more difficult outside the metro area to find and secure an attorney in a long to fill the whole year, to fill the whole fiscal year. And we're looking for different ways to make that happen. And I feel good about the fact that we can. What we were doing was not, I'm not saying anybody wasn't doing hard work. It was not proving effective.
You do have a question, Whit Park?
Thank you, Mr. Chairman. I'm a big fan of medical legal partnerships. Question was, are you working with any of the law schools? I know GSU Law has the health law partnership, which I came up through Mercer Law, certainly outside the metro Atlanta area. Is there any conversations with them with respect to building this out?
We will have, some of my conversations going forward are going to be how can we reevaluate this. Right now, the resources are for barred attorneys, and so working with the clinics at the law schools can be challenging in that respect because which I completely support and I'm excited about getting students clinical experience. But we're going to evaluate sort of all possibilities to make sure, because the legislature's been a great partner to us in this, and again, we feel very good about the economic return story for the state, but also for the industry as well, which of course a lot of the times those are hospitals that are carrying an indigent load already, and so their benefit is a collective benefit. So we feel good about the program. We are exploring different ways to make sure that we are maximizing our utilization. Anything else on the MLPs, Mr. Chairman?
Sorry, this thing hangs up a little bit. No, you're good. Thank you.
Thank you. I will then move across a couple of sections or points that you'll hear other presentations on, all the way down to section 6.7, which is the Resource Center. The Executive Director, Anna Arsenault, is here. She always is available to us. We'll talk about the operations of the Resource Center. But this is a request for a single staffing position to offset loss of revenue from other funding sources for the Resource Center. I expect the committee will be aware that the Resource Center's primary function is to provide legal representation in habeas proceedings for those that are death eligible in Georgia, or they're on death row, as it were. We are at 35 people under a sentence of death in Georgia today. That caseload for the attorneys has sort of remained relatively stable. This is not a new add of a person. They are seeing revenue that they have historically received from the federal government that is linked to their representations in federal habeas proceedings decrease because those cases are winding down, but they still have the same individuals that they're representing. And so the request is to keep the staffing essentially flat, but by the state picking up the loss of funding in that space. And so that's essentially the nature of the request.
Okay, yeah, no questions on that.
All right. That's the end of my presentation, Mr. Chairman. Appreciate your time, and obviously we stand ready if you have questions after, we're not limited to what we hear here.
Fantastic. Before he steps down, are there any questions for him? Thank you so much, Justice. Appreciate it. Okay, Supreme Court. Thank you for being here.
Mr. Chairman, members of the committee, thank you for having me. And it's great to be back in this room. I had the opportunity and the privilege, thanks to Chairman Hatchett and Chairman Tiller, to present during the Joint Appropriations Committee's weeks. And so I've already been over this with some of y'all, but I will hit the highlights real quick. We are Section 10 in your tracking sheet, and we have 6 items. 10.1.1 is just an annual pass-through to the Department of Public Safety for the agreement we have regarding the state trooper who provides security for the Chief Justice. Happy to answer any questions about that, but that's a number that they just send us. So
I don't see any questions.
There.
Thank you.
There is one other item on a pass-through that I know budget staff knows about that relates to it's not on this list. It's an ERS adjustment that ERS sent us late in the process this year that works out to about just under $84,000. But I know staff has had that, and I'm happy to answer any questions about that as well if you have any. But
yep, there's no questions.
Okay. 10.1.2 is the adjustment related to the new model for judicial compensation. There are 2 parts to that. $366,000 of that is simply to annualize the salary adjustment that the General Assembly made last year, and as Judge Hightower mentioned, we're all very grateful for that. As you understand how the model works, the model also contemplates that there's a maximum authorized salary that adjusts each year that's based on a percentage of what the federal district judges for the Northern District of Georgia made 3 years ago. And so the second part of this number, the $238,000, would be the adjustment to the maximum authorized salary for FY27. And I'm happy to answer any questions the committee may have about that.
There's no questions.
Okay. And then 10.1.3 and 10.1.4 are both simply annualizing increases for staff retention that were made in the FY26 budget, but were made effective January 1st, and those 2 lines just annualize those numbers.
No questions.
And then 10.1.5 and 10.1.6 represent sort of the most significant policy shift that is present in our budget request, and it will be present in the Court of Appeals budget request as well. Judicial security has been a real top priority for us for the last several years and continues to be acutely critical across the country. And this reflects two positions, creating a position of Director of Judicial Protective Services at the court and a operations manager. And those positions would be responsible for a wide range of responsibilities, but not simply for our two courts. As I explained during the joint appropriations hearings, every trial court in the state has security provided by local law enforcement. The two, now four, I guess, courts in the state that do not have security provided beyond simply the physical courthouse security for the judges are the statewide judges, so the Supreme Court, the Court of Appeals, the statewide business court, and the new tax court. And so this would be creating those two positions principally to coordinate security issues like that. Nobody needs 24/7 work. Nobody needs to be driven around in black SUVs or anything like that. But there does need to be some serious coordination. Those roles also, though, would provide statewide support for Georgia's 1,600 judges in terms of tracking threats, in terms of training. And a lot of that work is ongoing already through a contract that the Court of Appeals and we had put together with Stan Cooper, who's here in the back, and is providing these functions already. And that was largely through the generous subsidy of the Department of Corrections, who he had worked for them for a long time. I know y'all all know him because he's been around this building for a long time. But he is now retired from the Department of Corrections, and so to go from simply having some contract support in that space to making that particular role permanent did require an appropriations ask, and so that's what that represents.
Do you have a question for that one? Representative Kelly.
I certainly support, unfortunately, the need for increased judicial protection for y'all, and I know Mr. Cooper's doing a great job for y'all. I just want to make sure I understand an efficiency argument in terms of us as legislators not putting pressure on an existing state law enforcement agency to set something up for this, like a specific piece of the GBI to handle something like this. Were there conversations like that before? I'm just thinking when you do talk about the statewide, aspect, their statewide network of special agents and things like that.
So, without putting words in anyone else's mouth, I will say we've had a lot of conversations with our state law enforcement partners around this. We had all those conversations, frankly, before we ever signed the initial contract with Stan. And I will say my communication with, Department of Public Safety, the Colonel of the State Patrol, is essentially, look, we know y'all are stretched thin. Y'all do a great job securing the building, but there's more that needs to be done, and y'all simply don't have the bandwidth to do it. And so we want to be creative and find efficiencies within existing systems. And really the idea here is to have a couple of positions at the statewide level with a focus on sort of monitoring and creative system building, but then leverage local law enforcement in the event of acute threats where you actually do need some bodies, and particularly off-duty local law enforcement so that there's opportunity for increased revenue for local officers. That's what $100,000 of the shared amount between the two courts reflects, 50 in ours and 50 in theirs, would be a $100,000 fund where in the event of a particular threat against one or more judges or justices, there would be funds to go and to hire off-duty officers to come in and to provide that physical protection to the extent that there's something required sort of more acutely. Y'all have funded a position in previous years relative to threat monitoring that's engaged with, that is a statewide law enforcement position. But beyond that, the statewide agencies simply don't have the bandwidth for that without going out and hiring additional folks, and that would be more expensive than this.
Okay. Thank you. I want to talk more with you offline about it. Certainly, I don't, think you're talking about threat management is something necessarily we want to, but I want to certainly know a little more.
Of course.
Thank you. Any other questions from the committee? Yep, got a few. Representative Holcomb.
Thank you, Mr. Chairman. Good afternoon, Mr. Chief Justice. One of the things that we've heard over the years has been on, and I think I've asked you this before, has been on the retention of your staff, which is critical to the functioning of the court. And it doesn't look like the amounts that are there are all that significant in the big scheme of things. And I was wondering if you could just give us some context or update on how you're doing with the retention, if these dollars you think will be enough to keep people with the court.
So, I mean, it's always challenging to predict people's future decisions, and when you're talking about as small a number of lawyers as we're talking about, individual decisions can skew things. But when you look over the past 5 or so years, our staff attorney turnover rate has been 75%. And that's in roles that historically were permanent career-long roles. And that doesn't include our term clerk positions that are designed for sort of young entering lawyers for 1 year. That's just the permanent positions. So is this a silver bullet that's going to solve that? No, but every little bit that we can get to help address that helps. And frankly, I know it completely apart from the economics, I know the morale of our staff attorneys is improved when they see us advocating for more resources for them, and they see the value that you and the General Assembly place on them by helping fund that.
Okay, thank you.
Thank you.
Whit Park.
Thank you, Mr. Chairman. Chief Justice, it was so appreciated your remarks during the State of the Judiciary.
Thank you.
With respect to the Judicial Protection Services, going off of the line of questioning from Representative Kelly, I assume that would be layered on top of the trooper agreement.
So the trooper agreement, and this is always awkward for the Chief Justice to talk about, it's just for the Chief Justice, in the same way that the Speaker, the Lieutenant Governor, and the Governor have protective details, the Chief Justice does as well. And obviously, when they're around the rest of the court, or in the building, the rest of the court and the judges in the building, enjoy the added security that provides. But it is not an agreement for the court or the Court of Appeals as a whole.
So just to clarify, the remaining justices, they do not have personal security?
That's correct.
That I do think should be addressed.
I have experienced this for a grand total of 10 months now, so after 10 years as a statewide appellate judge.
Thank you, sir.
Yeah.
See any other questions? Really appreciate you being here, appreciate your presentation, and appreciate what you do for Georgia, and thank you.
Thank you very much, Mr. Chairman, members of the committee. Really appreciate y'all.
Okay, we're going to mix it up a little bit here. Court of Appeals. Judge Brown, you want to go? You can come up front. Come on straight up the aisle. We appreciate you being here and being a support and going for us now. So,
absolutely. Thank you, Mr. Chairman, for having us here today. I can be as simple as you want me to be or to the point. I, too, want to follow both the Superior Court as well as the Supreme Court in thanking you for the salary enhancements of FY26, and that kind of gets us started. We're on page 5, and the first 3 lines of line items are 1, 2, and 3 are actually annualizing those specific enhancements. Line 1 is for the judges, 2 is for the staff attorneys as well as the professional staff, and 3 is for the court staff. The only real change is one that was mentioned previously and has been discussed with Ms. Anna and staff was the new multiplier with ERS. That's going to be a significant change of $131,187. But other than that, everything else is the same. Are there any questions as to the annualization of 1 through 3? The line item 4 has to do with, again, OCGA 4574. That is the maximum. If you were to maximize what federal district judges were making 3 years ago, that's what it would take to maximize that. Line item 5 is, again, the discussion of the $40,000. We took on a new judge in January of last year. That judge was non-commuting. The new judge is a commuting judge replacing a non-commuting judge, and that's the $40,000. That annualizes that number. Line item 6 and 7, that is the Judicial Protection Services. That's our half. That's everything that Chief Justice Peterson was talking about. Between line item 6 is our half of the program, including the salaries of the director and the deputy director, and line item 7 is one of the 2 vehicles that would be necessary for that program.
Great.
And then finally, line item 8, the $197,000, that is to annualize the cost of the cloud-based IT solution away from the hardware redundancy that we presently have. And we're in the midst of that transition as we speak. That's basically all our numbers.
Are there any questions from the committee?